Hello, everyone, and welcome to this episode of the Akkad and Koka Report. I'm your co-host, Michel Akkad in San Francisco, and my partner in crime, Anish Koka, is joining us from Philadelphia. Today, we are going to discuss a topic of great practical importance to physicians, and that's the issue of sham peer review. Now, peer review is the process by which physicians who practice in a hospital may be judged by other doctors for the purpose of determining whether they should remain on the medical staff of the hospital or be booted out. And unfortunately, the procedure by which this peer review process is carried out does not always follow the highest principles of justice or ethics, to say the least. With us to discuss the problem of hospital sham peer review is undoubtedly the world's expert on this topic. Dr. Lawrence Huntoon is a neurologist who practices in upstate New York. He is a member of AAPS, the Association of American Physicians and Surgeons, for which he serves on its board of directors, as editor-in-chief of its journal, and as chairman of its committee to combat sham peer review. Dr. Huntoon has published numerous articles raising awareness and educating doctors on the practice of sham peer review, and for many years, he and AAPS have tirelessly assisted countless physicians unjustly embroiled in this process. Larry, welcome to the show.
Thank you, and I really appreciate you and Dr. Koka having me on your podcast, as this is a really important topic that doctors should know about.
I agree. Before we start, can you, Larry, tell the audience a little bit what's the relationship between doctors and hospitals? Doctors are not employed, typically are not employees of hospitals, but they work in hospitals. So what's the arrangement between doctors and hospitals?
Yes, there's often some confusion, particularly among the public, many of whom do think that all doctors are employees of the hospital. And although there are physicians who are employees of the hospital, there are many independent physicians who are not. Both employed and non-employed physicians of the hospital are subject to what's known as medical staff bylaws. That governs the relationship between physicians and the hospital and represents a contract in most states.
Okay, so there's a contract that's made explicit by the bylaws of the hospital, so that when a doctor wants to practice in a hospital, he applies to join the medical staff, and then implicitly he signs on to the bylaws of the hospital.
Right, and unfortunately, you're supposed to, when you join the medical staff, acknowledge that you've read the bylaws, but I think that most physicians don't. They should, because it really is setting forth the expectations of both the physician as well as the hospital, what the hospital has to provide in performing peer review, for instance.
Okay. Now, it stands to reason that a hospital would want to, they may not know a doctor, or they may just allow a doctor to practice in the hospital on the basis of credentials and degrees and whatnot. But they need to have a say. If a doctor is incompetent or malpracticing or for whatever reason a danger to patients and whatnot, it stands to reason that they should have a process in place to review the performance of doctors, right? And to decide if a doctor can be allowed to continue to practice or not.
Absolutely. And I want to make it clear from the outset that what we're talking about today is sham peer review, which is bad faith peer review. And I and AAPS and ethical physicians are in favor of good faith peer review. That is peer review that's designed to make sure that the physician is competent and providing safe care to patients. We're in favor of that. The kind that we're not in favor of is bad faith sham peer review.
Okay, so when did that get your attention? When did you first hear about it? Because frankly, I was completely unaware of it, and I read one of your articles at some point, and then in retrospect, I thought to myself, oh, now I remember I attended the peer review process, a couple of years ago, somewhere, and that's really what it was. It was a sham peer review, I didn't have the words to describe it, but in retrospect, I'm pretty sure that that's what was happening. I mean, it seemed to me I was not directly involved. It was not my department, but I was a witness to it, and it seemed to me that whatever was going on was, seemed to be fishy. And so, how did you first find out about the fact that
Well,
sometimes peer review is not doesn't proceed on good faith?
first of all, I think you're in good company. I think the vast majority of physicians may not have heard about sham peer review, and many of them don't give it a second thought because they believe they're good physicians, they're competent, they provide compassionate care, they get along well with patients, the patients like them, and this will never happen to them. Well, so their first encounter and then knowledge comes when they're attacked. So my involvement in this dates back to about 2003 or so, when an award-winning journalist for the Pittsburgh Post-Gazette by the name of Steve Tweet did a year-long series called The Cost of Courage, where he delineated how hospitals often retaliate against physician whistleblowers, and some of the cases he reviewed were cases of sham peer review. And about that time, the Association of American Physicians and Surgeons started getting quite a number of calls from physicians who were victims of sham peer review seeking assistance. So in 2004, the AAPS Board of Directors formed the AAPS Committee to Combat Sham Peer Review, and they appointed me their chairman at that time, and I have been running the AAPS Sham Peer Review hotline on a pro bono basis since then, since about 2004.
So, is this something new that has just come about in the last 15, 20 years, or has it been going on all along? What's your sense of that?
Well, I don't think it's new. There have always been people who get in positions of power who find ways to abuse that power. And that's what we're talking about here is basically people who are in positions of power and can bring false charges against a physician and trump up a peer review and basically end the physician's career. So, I mean, I think it dates back a very long time.
Right. And so, what are the motivations for that? I mean, why would is it just competition between doctors and business I mean, on business competition that one group of doctors wants to kick a competitor out of the hospital staff, or what's your sense of what's going on?
Well, that's certainly a prominent one. Retaliation against physician whistleblowers is another one that's high on the list. You know, hospitals don't always like hearing about poor care or unsafe care, and sometimes they will act to essentially kill the messenger instead of doing something to address the problem. So retaliation against physician whistleblowers, certainly anti-competitive motives. For example, if you're going to do something that competes against a hospital, again, hospitals don't like competition. So if you plan on opening your own MRI center, for example, and the hospital has, of course, an MRI of its own, they may decide to take some action against you. But there are many underlying motives. I have seen attacks that are discriminatory based on ethnicity, sex, and other things like that. Certainly just personal animus sometimes. Somebody dislikes someone and is going to teach them a lesson, take them down a peg or two, and sham peer reviews one way that they choose to do that. So the motives are there's just a large number. Anything that you can think of that would be improper, people have done at some point.
Right. And do you think it's getting more common because just healthcare in general has become so difficult, much more competitive? I mean, the money is not as flush as it used to be in the 60s and 70s, and then there are new alignments of interests between hospitals and medical groups and doctors and whatnot. So does that breed more sham peer review now than in the past?
Well, certainly competition is one of the underlying things. In fact, there was a case called Patrick v. Burgett, which basically led to the passage of the federal law which governs peer review called the Healthcare Quality Improvement Act of 1986. And that law basically provides nearly absolute immunity to hospitals and peer reviewers for anything they do under the label of peer review. Even if it's totally wrong, even if it's contrary to the bylaws and denies due process and fundamental fairness, they still have a very strong immunity to protect them. And that type of law, where you have nearly absolute immunity for those doing the peer reviews, invites abuse. So I think we've seen much more abuse of the peer review process since that federal law was passed. You asked about competition. The case that led to the passage of HCQA was Patrick v. Burgett. It involved a surgeon who was invited to join a large clinic in Oregon. And they basically had things sewed up at the hospital. Very large clinic. They were all in positions of power. And the doctor declined to join that large clinic and said he preferred to go out on his own. Well, that didn't sit well with the group, who didn't even want the competition of a single independent physician. So they trumped up a sham peer review against this doctor, and it went to court, and it was an antitrust case which went all the way to the U.S. Supreme Court, and the doctor prevailed at that level. I might add that the AMA filed an amicus brief in that case in favor of those who did the sham peer review, whereas AAPS filed an amicus brief in favor of Dr. Patrick, who was the victim of that sham peer review. But he prevailed, and then the AMA and others cited that case as this would have a chilling effect on peer review if someone is allowed to prevail and get monetary damages, and we need immunity, and that's how the HCQA law became law.
Wow, that's amazing. So now there's a law that protects hospital and peer reviewers from immunity for essentially what are miscarriages of justice, except that it's not in the context of any legal court, right? It happens within a hospital, and they have some kind of procedure by which they can review a doctor's performance. But doctors, tell us a little bit does it vary from hospital to hospital, that procedure, and how fair it is?
Yeah, but before, can you tell us a little bit more about the law and what exactly the law says?
Sure. One of the things that the law says that you may find shocking is basically that physicians who are accused of doing something wrong in peer review are presumed to be guilty unless and until they can prove their innocence by a preponderance of the evidence. So that's distinctly contrary to the rest of our legal system, certainly in criminal law, where you're presumed innocent unless and until they can prove you guilty in a court of law. It's exactly the opposite in peer review. The other astonishing feature of that federal law is that it does set forth the requirements for conducting a peer review in a hospital. But at the very end of all those requirements, it says, if you fail to meet those requirements, that in itself does not prohibit you from getting immunity. So what a mockery of due process to set forth a whole procedure and then say, well, don't worry, if you don't follow those requirements, we're going to give you immunity anyway. So the answer to the other question is, of course, peer review procedures are very similar from hospital to hospital because they mirror the requirements under HCQA law. So they're very similar from hospital to hospital. The other thing to know about peer review in hospitals is it's a quasi-judicial process. So it doesn't follow the norms in a court of law. It does not follow the rules of evidence in a court of law. So such things as hearsay, which would never be admissible in a court of law because it's not reliable, are admissible oftentimes in a peer review hearing. Well, if it's not reliable in one setting, what makes that reliable in another? Absolutely nothing. The other thing is and there's many things, but there's no voir dire in hospital peer review. Voir dire is the process in a court where a jury is basically selected by eliminating those who either have some bias that's obvious against the plaintiff or defendant. And that type of thing doesn't occur in peer review hearings generally. There are some rare instances where it does, but in most cases, there is no process whereby a doctor can question these possible jurors on the hearing panel and find out if they have biases. And that's pretty important. The other thing is there's no subpoena power at a peer review hearing. So in a court of law, if you have a person who has relevant evidence, you can subpoena that person either to deposition or at trial to testify. But in peer review, if a witness under the hospital's control, for example, an employee or someone else who's financially connected with the hospital, if the hospital decides they're not going to produce that witness to be questioned, there's no subpoena power that the doctor can have in the hospital setting that would require that witness to come forth and be cross-examined. You have to go to court to compel them to do that. So it's a whole other proceeding.
So what an utter ridiculous joke this is, right? We have essentially a kangaroo court banana republic that's set up to kind of deal with physicians that get labeled as disruptive, whether that be with any real evidence or not. I mean, so essentially what you can have happen is some anonymous complaint be trumped into, because some anonymous complaint be trumped into something that's real, and really the onus is on the physician, and the deck is massively stacked against the physician in this regard. The thing that makes me the most angry about the process is that it is this utter ridiculous scheme is carried out by our colleagues. It's carried out by chairmen of medicine. It's carried out by chief medical officers. It's carried out by all the administrative folks, but they're clinicians, and it's so utterly disappointing that those are the folks that are the henchmen that carry this crap off.
And I think that's absolutely correct. And in 2004, the AAPS passed a resolution unanimously at its annual meeting that those physicians who participate in sham peer review are engaging in professional misconduct. It's totally unethical to bring false charges that are knowingly false charges against another physician and end his career. And I think your audience needs to understand that sham peer review, when it goes to its conclusion, and the doctor has an adverse action that gets reported to the National Practitioner Data Bank, that is a government-run blacklisting of physicians. And that physician will either have his career totally ruined as a result or many times ended, because all hospitals have to query that National Practitioner Data Bank before they put a physician on staff, and then every 2 years thereafter. The medical boards query the data bank to see if a physician is in it, and you may not be able to get a license, you may not be able to get on medical staff. If you're in insurance, which I know that congratulations, you guys are not, but the insurance panels.
Not so fast. Only one of us here.
Okay.
I wish I could say the same. Unfortunately, I'm not. But
so, in fact, that's one of the reasons why I invited you, Larry, here, because I want Anish to get more and more nervous. Although here it would be, you said not being on insurance panels is more detrimental or more protective?
No, it's just another negative consequence that can occur as a result of being reported to the National Practitioner Data Bank. And I just want to make one comment about what was talked about just a little bit earlier, the disruptive physician label. That is the most lethal label a physician can be given in a hospital, and it frequently leads to sham peer review and end of the physician's career. There is no evidence whatsoever that is needed to prosecute a physician in the hospital for being a disruptive physician. It's based solely on the accusation. And according to the Joint Commission, things like facial expression, tone of voice, and body language can all be used against a physician to prosecute the physician for being disruptive. Very subjective label. It means whatever they say it means. That's the way it works.
That's amazing. Larry, can you give an example, either a real life example or something that you think approximates a real life example for somebody who seems, let's imagine a member in the, someone in the audience here, a doctor who's on staff at a hospital. What could possibly happen? I mean, how does it play out? Because initially, they may not even, right? People don't even have a sense that they're being judged or that they're being put on trial, right? It can be insidious, the process.
That's right. And I've written an editorial on that, and there's often little warning signs, little attacks that precede the actual sham peer review, and doctors need to be aware of that and take note that even if the little attack seems resolved, when they keep coming up with more, that something big like a sham peer review may be coming. So if you're just talking, at a morbidity and mortality conference, for example, and somebody seems to be constantly bringing up nitpicky things that don't have a lot of merit, but they keep bringing it up at these morbidity mortality conferences, don't be surprised that at some point one of those people may get into a position of power and say, hey, you know what, we're going to get rid of the competition, get rid of this position.
You bring up, I think I read the editorial you're talking about. You bring it up, you bring up the sequence, and you talk about the multiple different techniques that are used very well. And the first one is the ambush tactic, and the ambush tactic and secret investigation. And the ambush tactic is where the office will get a call from some administrative staff, the secretary of someone in administration, saying that a meeting has been called for, and the meeting is always called for as soon as possible. There's a tone of urgency and there's a tone of seriousness to it. You ask, what exactly is the meeting for? And someone says, oh, it'll be a quick meeting. And then you show up at the meeting, and you're faced by the chairman of medicine, you're faced by some other administrative clinical person, and it's anything but friendly. This is all, again, from your editorial. And and again, you've arrived at the meeting unprepared. You have no idea what the meeting's about. They have records which frequently they will not release to you, and they will then, in somber tones, read the accusation, and kind of put you on the spot and try to make you squirm about something that, who knows when it was. If it was 6 months ago or 8 months ago, and it's an instance you don't remember, you may stumble, you may not, you may appear in a bad light, and that all gets, it all can get, I should say, recorded, and that can all get, all be made in the further process to make you look especially bad. Is that correct?
That's pretty correct. I published the tactics characteristic of sham peer review, and also did a video presentation on that same topic about 10 years ago. And I can tell you that the hospitals and the attorneys who represent hospitals were not very happy with me for basically revealing their playbook of dirty tricks. And certainly the ambush tactic is a very common one, where they portray it as a simple and formal, friendly meeting. And it is, of course, usually very formal and very unfriendly. And like you said, the physician is not told, even if he asks or she asks, what is this about? Don't worry about it. We'll talk about it when we get to the meeting. And of course, everybody at the meeting knows exactly what it's about, and they're very well prepared. And so the physician goes and finds himself sitting across the table, as you said, from like the chief of staff, the chief of his division, the hospital administrator, the hospital attorney. So it might be 4 or 5 people sitting on the other side of the table. It's very bad to go to one of these meetings for a number of reasons, because the hospital keeps the record. And if you think about it, it's not just he said, she said type thing, because you've got 4 or 5 people that are going to stick to whatever the story the hospital wants to stick to. But you're right that since the physician does not know what it's about, and everybody else does, the physician does stumble trying to recall the case from maybe a year or more ago. And when you stumble and fumble, it makes you look guilty, which is one of the goals of the ambush process. So that is one of the common ones that we see used all the time.
The other thing you mentioned was, you mentioned it in the editorial, and you mentioned earlier about the guilty until proven innocent. This is from the HCQA law you're saying, which is the Healthcare Quality Improvement Act. Is that correct?
That's correct, and you'll often find that same thing in the bylaws. and it's in the HICWA law, it's guilty until and unless proven innocent by a preponderance of the evidence. And sometimes the hospital makes that even worse on the physician by raising the standard of proof required to clear and convincing evidence, which in the last case I just participated in a couple of months ago, the hospital attorney informed the hearing panel that clear and convincing really meant beyond a reasonable doubt, which is the highest level of evidence that is used in, for example, criminal cases.
Right.
And it's totally false. Never should have informed the hearing panel of that. It's totally false. Any attorney should know that.
Right. The other interesting tactic is that this numerator without denominator, which is essentially, it doesn't matter if you've done 1,000 cases, and you're 10 times, your volume is 10 times that of anyone else in the hospital, but if they'll pick out 2 of those cases and say, look at this, look at these bad outcomes, and
that's a very common one used against particularly surgeons. Like they'll say, look, there have been 2 horrendous or 3 horrendous complications. We have to do something to protect patients. But of course, when we compare complications from one surgeon to another or physician to another, we're talking about rates. Well, a rate involves both the numerator and denominator. And conveniently, oftentimes the hospital leaves out the denominator and simply focuses on the numerator. Now, since I published that, some of the hospitals have gotten a little more devious and clever. And instead of simply eliminating the denominator, they have started manipulating the denominator so as to reduce it, so as to make the rate look higher. So they're always coming up, it seems, with more and more clever and devious tactics.
Larry, are doctors who are employed by hospitals or large hospital system, are they in a better position or not, or it doesn't matter?
Well, I think in general, they're probably not in a better position. The reason being is a lot of the contracts that physicians have with hospitals, basically, a lot of them say that when there's termination of the physician's medical staff privileges are automatically terminated. Well, if the hospital decides to terminate you for incompetence or patient safety issues, and your privileges are automatically terminated, I should mention, without peer review hearing or appeal. That's part of the contract. Then you have no due process and way to rebut it. And you do get reported to the data bank, and without even having a chance to go before a kangaroo court, it's basically over. And of course, the other thing is there's many pitfalls to hospital physician contracts, but they can also require the physician to do things that the physician may not feel comfortable doing. So in one case, a colorectal surgeon was recruited to a small hospital that didn't have a colorectal surgeon, thinking they would bring in a lot of money, new revenue for the hospital. And when the revenue stream did not appear as anticipated, they looked for a way out of the contract without having to pay the doctor. The easiest way out was to take away the doctor's privileges, because if a doctor loses privileges, the contracts always say, well, that automatically terminates the contract, and it doesn't cost a hospital to do anything. It doesn't cost them anything to do a sham peer review. So this particular colorectal surgeon, they tried to force on ER backup call, and the surgeon said, look, I haven't taken ER backup call with gunshot wounds and stab wounds since my residency 35 years ago. I don't feel comfortable doing that. But it said in her contract she was supposed to do all the services they wanted her to do. So what happened in that case, and in sworn deposition, the CEO of the hospital testified that he altered the wording of the surgical committee meeting minutes to state that the doctor said not competent to do instead of not comfortable. And that change in wording led to a sham peer review and the end of this physician's career.
Wow, that's amazing. I think no doctor is safe, really, because you can have enemies if you do a good job. You can make enemies just from doing a good job. You can make enemies if you're part of a large organization, because the organization may have, different goals that are not necessarily aligned with what you're trying to do as a doctor. and you can make enemies if you're independent. So I think it affects really any doctor. It seems
So
clear. Go ahead.
it can potentially affect anyone, and being a good doctor and having your patients like you and like what you do and how you treat them, that's not protective, unfortunately. And as you point out, sometimes that can even make you a target for some physicians who are not as good in getting along with patients and treating them well. So again, it's kind of a way to eliminate the other physician to make themselves look better.
What tools do we have? Does the physician have at his disposal to kind of fight back, or how does one respond once one is embroiled in one of these things?
Well, as you know, I wrote another editorial on that, Sham Peer Review, Disaster Preparedness and Defense, that goes through some of the things that physicians need to do. It helps to be prepared ahead of time, but certainly at the earliest opportunity, when you perceive that something like a Sham Peer Review is coming down the road, you need to get a good, knowledgeable attorney on board as early as possible to protect your rights. And that's probably the most important thing that one can do. And the other thing I would recommend is that physicians read their medical staff bylaws, particularly the sections dealing with corrective action, which is usually around Article 8 or so, and the provisions affecting summary suspensions, precautionary suspensions, and the like. So read your bylaws.
Great. We'll have all these articles of yours, Larry, linked on the show notes, and they're all free access. So they're, people they don't need, there's no paywall and so forth. So,
right.
And APS is an entire page with resources and videos and whatnot about sham peer review and what to do in case you get, somebody gets embroiled in one of these things.
Yes, and we encourage people to call us as early as possible. It doesn't do a lot of good once you've been out in litigation for 10 years and it's very late in the process to call us. But call us early on. We can often provide information that might prevent a disaster. I can tell you that on the AAPS Sham Peer Review hotline, one of the most important pieces of information I give out is to physicians who are very frustrated. They can see they're not going to get a fair hearing in the hospital, and they just want to get out of there. They just want to resign and leave. And what I tell them is, if you leave while there's an open investigation or peer review ongoing, you will be reported to the National Practitioner Data Bank. Your career will likely be over, and you will have no due process rights at all, such as fair hearings or appeals in the hospital. And hospitals like that. They try and coerce physicians to resign. They will often tell the physician, look, it will go better for you if you just resign. You won't have to go through all of this messy disciplinary process. If you just resign, it'll be easier, and you won't get, some of them even tell them they won't get reported, and then the next day they do. So beware of that.
Right. That's amazing. I mean, it's so critical to be prepared and to know ahead of time, because, as you said, essentially there's no due process. So once the gears are have moved far enough, then physicians have very little recourse.
Yes, and in a sham peer review, as I always tell people, the truth and the facts don't matter because the outcome is predetermined and the process is rigged. So when a physician's going through the process in the hospital, it's necessary to go through it and complete it before you can really file a lawsuit. And the one thing you want to make certain of as you go through the peer review hearing is that you have an independent reporter, such as a court reporter, to take down who said what. Don't let the hospital keep the record, because oftentimes they will want to keep the record. Trust us, it will be okay. We'll keep the record of who said what. Don't do that. Get a court reporter as a physician, even if you have to do it at your own expense, because what you want to do is preserve the record so that when you go to litigation, you have something independent and reliable to cite.
Right. Larry, is this unique to hospitals, or does it also happen in large medical groups where a partner in the group gets booted out for similar reasons, and or is that more difficult in a medical group setting?
It does happen in large medical groups, and I was once invited to go to a large clinic and review some of their procedures, and they decided against that at the last minute. But it does happen in large clinics. It also happens at medical boards. Medical boards do it, but it is primarily something that occurs in hospitals.
Well, Larry, I mean, I can't, thank you enough and thank the work of APS, what the APS is doing, because you guys are the only guys out there trying to defend innocent doctors who are trying to do the right thing.
That's absolutely true. We're the only national medical organization that is doing anything to try and stop and oppose this growing scourge of sham peer review. And it's not just a doctor issue; it's a patient issue too. Because when the physician's career is ended by a sham peer review, then that good, competent, compassionate physician is no longer able to treat the patients, and the patients lose out on good care as a result. So it's a patient issue as well as a doctor issue.
For sure, and all of that. But I think you've intervened and you've helped doctors in the process to really avoid. But I mean, so it's not. It seems sort of gloomy, but early recourse to your advice is extremely helpful and can allow doctors to to regain the autonomy that they might have lost if they weren't fighting back. It's important not to roll over and just take it.
It's a very scary process, and again, I'm grateful to both of you for having me on the podcast to help explain this a little bit to the audience.
Okay, well, thank you very much, Anish. Any last question for Larry?
No, that was really wonderful, Larry. So it'll be good. It'll be good to have all of this was utter Greek to me, and really no idea that this is all going down, or this was the process that was so terrible. I just want to highlight again the fact that it's so upsetting to me that this is not only is this other physicians that do this, but it's also the fact that every one of these organizations that you look at that are very prominent, like the AMA, the ACC, you name the physician organization group, and why is it that none of these folks are talking about this? It's really embarrassing and sad.
There was, you bring up the American College of Cardiology, and there was an editorial written in 2000 by the editor-in-chief of that time, Dr. William Parmley, and he dealt with this issue of sham peer review. And one of the cases he reviewed was the case of Dr. Larry Polliner in the Dallas area. You may be familiar with that one. An interventional cardiologist who was a victim of sham peer review went to trial. The jury awarded him $366 million, a penny of which he never saw because the hospitals appealed to the Fifth Circuit, and the Fifth Circuit found that the hospital had immunity. So the American College of Cardiology, the editor-in-chief, suggested, why doesn't the ACC have its own independent peer reviewers so that when an issue arises involving cardiologists in a hospital, it can be sent for an unbiased, impartial review by people who are with the American College of Cardiology. And that suggestion, an excellent one, went exactly nowhere.
That's interesting. Bill Parmley was my chief of cardio. When I was a fellow, he was the division chief at UCSF. He retired soon after, but after he retired, the ACC became very involved in running databases of outcomes that hospitals are essentially forced to subscribe to. There's one for interventional cardiologists. There's another one for electrophysiologists, and I strongly suspect that these databases now are used against physicians. Are used as part of these sham peer review processes. It's going to be more and more common for these databases to be used for that purpose. To tell a doctor, look, you're outside the the standard deviation or whatnot, and so forth, and that's another thing.
It's like giving the rope to hang you with, basically.
Exactly.
And
exactly.
too bad that people didn't follow Dr. Parmley's really excellent suggestion. I mean, who could oppose an impartial, independent review as opposed to one occurring in the hospital, which may be very biased and partial?
Right. Well, I'll try to dig up that editorial, and I'll put it on the show notes as well.
Yeah, and it reflects. I think it reflects a culture shift that we've seen just in our careers. Even my short career, from when I was in training to becoming an attending. That what the priorities of the heads of clinical medicine were now. I mean, who the chairman of medicines are now and what their priorities are significantly different than I think what they used to be, and it's a sad state of affairs.
I think that's a correct observation.
Well, Larry, thank you again for joining us, and I'm really happy that our audience will hear your message and what the APS is doing. So thank you.
Thank you. It was my pleasure.
All right. Bye-bye.